couple of decades, I should say couple of decades, but maybe the first decade when new territories become part of Hong Kong, the Hong Kong government find that the land problem in new territories were many. So, for example, when they try to ascertain different land lots, LOT lots, they could not really be sure. Now they may consult the Chinese title document. Now in those days, when they describe a piece of land, nowadays we can make use of all kinds of scientific method to ascertain the boundary of land. In those days, they would say, oh, on south there was a rock, there was a big piece of rock, then a river was on the southwest side, and a big tree on the north, etc. But by the time that title was created, say 100 years ago, by the time the British government go to the site, tree, where's the tree? River, no river. So they could not really ascertain the boundaries of different land lots in the new territories. Now, also, under the Qing law, the basic principle was that land was held in perpetuity. That is just like freehold. If you purchase this piece of land, you can hold this land forever. If you die, you pass the title of the land to your son. And they divided the land into two layers, you may say. Now, the owner of the land is said to possess the right to the land bone, and the tenant, of course, the owner also owns the land, the skin. But when the owner leases the land to a tenant, the tenant is said to possess the right to the land skin, 地皮. Now, that's why nowadays in Hong Kong we always say, 有塊地皮啊，想拍賣. In fact, it comes from this old language, this land skin, so to speak. Why we say land skin? Because all land in Hong Kong are on leasehold. So the land is land skin, but not the land bone. Land bone belongs to the state of PRC. And one more thing, if you have pay attention to the news yesterday, and in fact continue to discuss today, there was an announcement that the government is considering to relax the condition for selling of land held by clans and family, the Zhou and Tong. Because in the new territories, they have this kind of land holding. Now, if someone was successful in this life and acquire many lands, they were afraid that if they die and the sons inherit the land, they may not be good sons. They may lose all the land accumulated by the father easily. So they set up a trust similar to the concept of trust, similar to the Western concept of trust. Now, actually, Zhou is this one, and now we use the English word Zhou. Now, it was someone, Mr. Chen Daiman, very successful in his life. So he put all the land he collected in his life under a trust. And he used his own name. To form a Zhou, he's the ancestor. And this trust would be managed by some manager, 司理人. They are just like the trustee. They will hold the legal estate of all the land under the Zhou. Now, of course, the land will be kept under this trust forever. In theory, the sons or male descendant could not sell the land. Could not sell the land because Chen Daimen wants to keep the land for all generations to come. And the income derived from the land could be used in different ways. Well, usually this guy will make a decision. I will use the income for education of my, descendants. So if you got a position, a place at the university, you got scholarship for that. And they may be during spring and autumn, usually the Qingming festival and the Chongyang festival. All the families would then gather in the ceremony, the cemetery of this guy to pay tribute to him. And at the same time, the income would be used to purchase pigs. In the old days, real pigs. They were already killed. All the pigs will be there. Oh, how many sons do we have? Oh, 3 sons. Okay. And then you get the pieces of meat back. And during autumn, they would also share some grants, collected from the tenant, so that even though this descendant could not make a living, decent living, they could rely on the Zhou to get some income, Or they would say, I will sponsor anyone who practices as a lawyer, for example. All kinds of different specific purposes for this kind of trust in the new territories. And the rules under this trust would be, normally you cannot sell the land. Particularly, in my practice, I come across a term. I don't know how to translate that in English, so we just use the transliteration, 上田.田, of course, refer to the agricultural land. If the land is classified as this one, then under the Chinese custom, you cannot sell this land. The land will be kept by the Chinese trust forever. For other land, if really the descendants are no good children, they could not support their own life, they need to sell the land of the Zhou, then all members of that Zhou have to give consent to the sale. Therefore, it is very difficult to get a piece of land owned by the Zhou to be sold to a third party. Particularly nowadays, many members of those new territories clans have immigrated to Europe or other parts of the world. Virtually, it's not possible to get the consent. And therefore, the government now is talking about lowering the requirement for for the consent for the selling of this land held by the Chinese trust. So this is a problem, because in England you cannot hold a piece of land on trust forever, because the British common law tradition, in that tradition, it is believed that land is precious property. You have to use the land. You cannot just keep it and not use it. So, because we do not have to study trust law, and we may not have chance to learn about these rules. In the common law, a trust can only be set up for life plus 21 years. That is, for life of one of the person. It could be the trustee, it could be one of the beneficiary. And then after that person die, you can only hold the property on trust for another 21 years. Once this 21 year expires, the land has to be held by a person. It cannot be on trust forever. So this kind of concept is different from the Chinese trust concept. The Chinese trust is supposed to hold the land forever, for all the descendants of the single ancestor. And they are also what we call the customary mortgage, known as mortgage by way of Form C. What does that mortgage mean? Now, I borrow money from this gentleman. I use my land as security. Now, in the English or common law model, I will transfer my legal estate to him. But in the Chinese model, I will just surrender the piece of land to him. He can stay on my land. And of course, there is a day for me to fully repay the loan to him. If I can fully repay the loan to him on that particular day or before, he has to give me back the piece of land. But during this period of the loan, he has no rights to get any interest for the loan, because he already got the benefit of enjoying my land. Now, this kind of concept is also different, therefore, from the English concept of mortgage. And in Qing law, we do not have an official concept of adverse possession. So you can occupy my land, but anytime I wake up, I can just, please go, I want my land back. But the English government or English common law has this concept of adverse possession. Therefore, many people who were, simply occupying the new territories at those days try to take advantage of this new system and say, I not only stayed there for 20 years, I stayed there for 15 years, so this land should belong to me. Now, the Hong Kong government at that time could not ascertain whether this guy actually has stayed on that piece of land for 50 years. So they have to set up a court to deal with all these land problems in the new territories. The land court was established by the New Territories Land Court Ordinance number 18 of 1900. And it was responsible for creating a system of land in new territories, including the demarcation, the division of different land lots, determining the ownership, and deciding on the titles to be given to such lots, whether they should be agricultural land, whether they should be used as domestic land, etc. And they also deal with the so-called claims of adverse possession. Now, the land court decided to divide the land in the new territories into demarcation districts and then subdivided into blocks. Now, in Hong Kong, on Hong Kong Island, or in most land on the south, in the land south of Boundary Street, we only have lot number, Marine lot, or just lot, New City lot, etc., to describe the piece, the land lot. But in new territories, we would describe it with demarcation district number. For example, in Yuen Long, demarcation district 1. And within this particular demarcation district, they divided the land into different lots, give it a number. So for land in the new territory, you would have a description like this: lot 1, 2, 3, or whatever number, in demarcation district whatever number. Okay? And at the same time, they decided that they are not going to give each lessee a separate, at those times called crown list. Instead, they will give one crown list for an entire block of land. Therefore, if you are studying in, if you are working in a law firm, you should have heard about the term block crown list. Now it is called block government list, because it is a list issued to an entire block of land. And then individual landlord was recorded in the schedule to the block crown list. In the schedule, that means annex to that to those block crown lists. And after the ownership were determined and record in the block crown lists in the schedules, administration of land in the new territories was carried on by the district officer, which is different from the situation in Hong Kong or Kowloon. It is the district officer who would be dealing with land transaction, registration of land transaction, etc., etc. And nowadays, if you want to get a license for erecting a small house, you still have to go to the district officer, but not the land department. So many land matters are still responsibility of the district office. For example, this land held by Zhou and Tong about small house, all will deal with district office. And because it is land listed from Qing dynasty, Qing government, therefore not only the English law or Hong Kong law would govern the new territory lands, but also the Chinese customary law. And you should remember Section 13 of the New Territories Ordinance said that the courts shall have power to recognize and enforce Chinese custom, and the case law said that shall have power actually means the court have no choice but to recognize such Chinese custom, the Dai Qing, like the Qing Code, and express statutory protection of the succession right of intestacy, that is when the person died without a will in the male line in Part 2 of the New Territories Ordinance. So in the past, in New Territories, if someone died without leaving a will, his land property will only go to his son. If he has no son, go to a son of his brother or anyone who is closest to him and in the same family name. Daughters, I'm sorry, you have no right to inherit the land from your deceased father, even though your father has no son. And this protection of the male succession right on intestacy was only abolished in 1994. You know, those are old enough to remember that the previous the deputy director of environmental of Hong Kong, you know, the last one, Ms. Luk Kung Wai. It was she. She was a legislative councillor at that time, introduced this law in the Legislative Council to abolish the domination of the male right in the succession of intestacy or in the new territories. Because under the Qing Code, daughters have no rights to succession to intestate estate of their father, but they have a right to dowry. You have this right to get some property, some money from your father before you die, for the females. Before you marry, I'm sorry. Before you marry. Other than that, you have no right to enjoy the property of your father. And in fact, I make use of this particular rule in one of my case to protect, you know, a landowner in Changzhou. Changzhou is one of the outer islands, also belong to new territories, in which the Qing Code and Chinese custom would apply. Now, the intestate estate ordinance applied to new territories land so that both sons and daughters enjoy the same right since 1994. And the land not exempted from the Part 2 of the New Territory Ordinance also treated differently from other land in Hong Kong. For example, if you want to, you know, say for example, carry on certain business, you have to comply with the requirement of town planning ordinance. Say for example, if you want to run a furniture house, you cannot do it in Central. You cannot say, I want to lower the price of, say, Admiralty Center. I will set up furniture house here. So I'm sorry, you cannot. The town planning ordinance has already prescribed the possible business to be operated in the Admiralty area, and furniture house is not one. And for building ordinance, but in new territories, this ordinance would not apply. And therefore, there was a particular ordinance about buildings ordinance application to the new territories ordinance, enacted to apply some of the building ordinance. I mean, to apply building ordinance to some of the lands in the new territories. And in fact, the buildings ordinance application to new territories ordinance still allow people in new territories to build house without compiling with the building ordinance, you know, to get certificate of exemption from this building ordinance. And the ding up, the small houses were built under this particular provision. And, you know, again, for the old days, it's no longer important. Before 1997, the Hong Kong government was poor. You know, when they resumed some land in the new territories for public purposes, you know, according to the Peking Convention, they have to pay a price, but the government has no money to pay. So what they did was they issued what they call letters A and letters B to the landowner. Such letters can be used to exchange land later. And therefore, in fact, those developers, the 4 big developers in Hong Kong, has collected numerous letters A and B before 1997, so that when they bid land, other land in Hong Kong, they can use those letters to set off part of the premium to be paid. But before 1997, June 27, there was a new ordinance passed, so that nowadays, if you're still holding this letter, you can only get some monetary compensation. Basically, letters A were used when a speedy resumption was required, and letter B was issued where the notice of resumption has already been gazetted. Just for your information, it's no longer important nowadays after 1997, because this particular ordinance, New Territories Land Exchange and Entitlement Redevelopment Ordinance, convert all such letters into cash payment. The developer could not make use of these letters to exchange land entitlement. Okay, the Zhou and Tong, Chinese family of clan institution recognized under the New Territories Ordinance, and they are also the vehicles for holding land property. We've already mentioned some of the concept. So it's a trust held for the benefit of the clan, of the lineage, of course, the male lineage. Only the son will enjoy the right. And the Zhou was usually created posthumously by the heirs of the deceased landowner. That means that when Chen Daiman died, their son would then collect all the land and set up the Zhou. And in most cases in the New Territories, it is for ancestral worship, just to pay tribute to the father, those qi tong. You put all the dead, deceased person of the same family name under the same roof and pay tribute to them. And Tong was similar institution, but usually created by landowners inter vivo. That means during they are still alive. Now, usually, if it is a Tong, then it would be some kind of cooperation, between different landowners. Maybe they have only 1 or 2 pieces of small land, and they want to collect the lands together, or neighboring land. If we can combine the 2 land, that piece of land would be more valuable, and therefore they set up the Tong. And again, the land will be kept in perpetuity for various purposes. And there are other variations, sometimes called Wu, sometimes called Yun, and again set up by the different families, and then use the income of the land for various purposes. They can be used to worship certain gods. For example, in Tuen Mun, there is a Tien Hou Hui. In fact, in my practice, I have dealt with this particular institution. When they try to sell a piece of land under this Hui to my client. And this is what I already said. General rule for English trusts to be held for the duration of a life plus 21 years. So this concept of keeping the land on trust forever is not known or recognized in the new at the common law. But nowadays, but the reason why they were being recognized is that the New Territories were only listed to the British government for 99 years, and the British government did not want to, interrupt the oral original land holding system. And therefore, they allow this Chinese trust to exist. So these are the short description of this customary trust. There is managers as legal owner holding the property on trust for the benefit of claim. Now, the member, every male descendant of the common ancestor, will automatically become entitled at birth. So once you give birth a son, this son already become a member of that zhou or tong. And the official recognition is to light a lamp in that worship hall. It is important because that means your son is now registered as a member, and each member will have the same benefit. And this interest in the land of the zhou was only a lifetime interest. You cannot pass it on as your estate, because once you're born, you acquire this interest in the land. But once you pass away, that right, that interest also expires. And land held under the Chinese custom, normally inalienable and indivisible. You cannot cut it into small pieces and sell part of the small pieces to the outside or third party. And in order to protect members, because the British government, after they ruled Hong Kong for a while, they know in a big Chinese family, it is always the old men who have the say. They may, take advantage of the authority to exploit some weaker members, and then they may just sell the land for their own benefit. Therefore, under Section 15, the law now requires, if the manager, being the legal owner, they can sell the property, wants to sell any land held under the Chinese trust, they have to get the consent of the Secretary to the Home Affairs, the supervisor of all district officer, Secretary to Home Affairs. And in that case, they can give protection to the weaker members in a Chinese trust, the zhou or tong. And in practice, the secretary will not give consent unless the alienation, that the sale and purchase or transfer, has the unanimous consent of all the members. If there are 100 members, you have to get all 100 members' consent to the sale. And that's why it was rather difficult to sell a piece of land held under the Chinese trust. And in theory, under the customary law, if all members unanimous consent to dispose the land, the disposition will be valid even without the consent of the secretary. But the difficulty is that in practice, it may not be easy to prove that all members consent, unanimous consent, because it is even, first of all, difficult to prove that you have all members giving consent. Who are the members? So nowadays, if you want to purchase a piece of land held by the Chinese trust, the most safe or safest way is to get the consent of the Secretary for Home Affairs. If that's the case, you will get good title. Otherwise, you will get an empty title. You only get the legal ownership, but not the beneficial ownership of that piece of land. And Section 15 actually gives a method for the disposal of such land held by the Chinese trust and allow the manager to execute the assignment for sale. So first of all, the manager must be appointed by the members and register under the New Territories Ordinance. So whenever a manager passes away, the members of that Zhou or Tong would gather together and nominate another manager. And this manager has to register his name as manager of that particular Zhou under the New Territories Ordinance. That is to say, they have to go to the district office of their village and register. Now, once they get this registration, then they would have the power to execute any document for the sale of the land held under the Zhou. But this is only the first step. The second step is you get the consent of the district officer, or the Secretary of Home Affairs. Of course, the Secretary of Home Affairs would have too many things to do. So normally, it would be the district officer who gives the consent. And they should also get the consent of all members of the Zhou or Tong. And this consent will be inferred if no objection is raised to the DO, to the district officer. Therefore, whenever a piece of land held by the Chinese customary trust is going to be sold, the DO would then post notice around the village of that Zhou and give usually 1 month to 2 months for any member to raise any objection to the sale. If no objection is received, the DO would consider all member has already given consent, and then the DO will give his consent to this sale. The fourth step is the instrument of assignment, because when you sell a piece of land, you have to assign the title of the land to the purchaser, and the document to assign that title is called assignment. So this assignment is executed in front of the DO, so that the DO knows what you are doing. But nowadays, this is not often followed. The most important thing is to get this consent, because once he consents, the court would treat that whether the assignment executed in front of the DO is not that important. And if your land held under the Chinese trust is not disposed of according to Section 15, in the fourth step, or at least the three step, then the purchaser would not have a good title to the land. And the title is supposed to be void. And then, of course, in theory, you can say that if all members execute the assignment, that would be enough. But there is always the practical difficulty to prove that all existing members actually consent. Therefore, the government now is considering lowering the requirement for selling of this land held under Chinese trust. You can see why. Okay, so land held under Chinese customary trust by the Zhou and Tong is one big problem for many lawyers in Hong Kong. Many lawyers, when the client came to them and say, "Well, I have some land in New Territories," they would say, very good, and I will introduce you to my friend who is an expert, something like that. They don't want to bother about the law. The second big problem for New Territories land is the small house. I think all of you should know about the small house because of the recent publicity, either in court cases, etc. Now, that policy was officially implemented by the government in 1972. Now, in those days, one of the problems for Hong Kong is housing. And in the 60s, 1960s, government began to build public housing, 公屋, for residents in Hong Kong. But of course, there are too many people, too little housing available. So the New Territories indigenous villagers argue that, well, we do not have much opportunity to enjoy the public housing. Why don't you allow us to build houses within our villages or, in the land nearby? So that concept was accepted by the government. So in the old days, someone can build a house, a small house, within their own village or 300 feet from the village. And the government may, in the very early days, grant you a piece of land for free, or a concessionary premium, that means a lower land price. And if you own a piece of land yourself, even if that piece of land is agricultural land, which in theory would not be used to build house, the government would allow you to build a small house. And building ordinance was not applicable because the government has designed a model for the small house in terms of size, in terms of height. 3-story, 27 feet high, 700 square feet for the area. Now, if you just follow this model, you don't have to hire any architect to design the house for you. And therefore, building ordinance was not applicable. And these houses are now known as Ding Mok. And all indigenous male villagers over the age of 18, when they reach majority, were entitled to apply for a piece of land or get a grant at a concessionary premium, or if they have their own land, they can ask the government to grant them a free building license, building permission to erect the small house on their land. In fact, this is the problem nowadays. Many developers, they owned land in the New Territories. They divided the land into small land lots for building small house, and they then purchase, under quotation mark, the indigenous villagers' rights from indigenous villagers. And these indigenous villagers will then use their name to apply for the free building license. And then, of course, the developer will then build the small house on that land lot and sell the house and earn profit. And the indigenous villagers will get a sum of money for giving up his own right. When I first practiced in Hong Kong, the price for the indigenous villagers to sell their Ding right was about 100 to 150,000, 10萬到15萬到啦. And in those days, the entire small house worth about 4 to 5 million. Now, the common market price has risen to 300 to 500,000. But do you know how much one small house costs you? Say in Yunnan, not really close to the city. It would be around 15 million. Now, of course, there is some cost for building the house. I think it would be around 2 million nowadays, and for all the paying 500,000 to the indigenous villages, and you can see how lucrative that profit would be, and the developer would have 100 small houses built in the same area. Now you can see it is really a cash generating machine, and that's why there are so many people in the new territories are taking advantage of this policy and become billionaires. And well, because the house were supposed to allow the sons to live in the same villages or nearby, and take care of their father and mother. So at first, some small house built cannot be alienated, cannot be sold or rent to a third party until 3 years expire after the date of the certificate of compliance. Certificate of compliance was the certificate given by the district officer that this particular small house has complied with all the requirements by the government. And after the 3 years, the indigenous villagers is then entitled to pay a premium, to pay a sum of money to the government, and thereafter free to dispose of the small house. But nowadays, many small house would not be subject to this 3 years restriction. And once they got the certificate of compliance, they were already entitled to pay a premium to the government and then sell the house to the third party. And the condition for sale would include the owner of the house to create a deed of mutual covenants, because there are 3 levels, right? The ground floor, the first floor, and second floor. So they need them to create a deed of mutual covenant, just like a multi-story building, to allocate the right and liability of the owner of each floor. And you cannot say, for example, you have a house here, 3-story. Now, you can only sell or rent out the entire floor. So either the whole house, 3 floors, or 2 floors, you keep one, it's okay. But you cannot vertically cut the house into 2 halves and say, oh, I want this half, you want the other half. No, you cannot do that. You can only dispose the house horizontally, but not vertically. So if you come across a house that say, oh, you can have half of my house, the left half or right half, then it must be illegal structure. Okay? So, and if the land is actually owned by the so-called indigenous villagers to begin with, then the 3 years restriction would not be applied. Once the certificate of compliance is issued, they can pay the premium to government and sell the house. And this is the most common way for the developers to dispose the house. And in fact, this is a very good policy for the indigenous villagers, because if the indigenous villagers does not want to pay a premium, now they can occupy the house for 5 years after that, they can sell the house without paying any premium to the government. And during these 5 years, they can also lease the house to tenants. And sometimes there's also one possibility of assigning the small house without paying premium. That is to assign the house to another indigenous villagers who has this right to build a small house but has not used that right. If that's the case, then the house can be sold to this indigenous villagers, and the original owner is not required to pay the premium to the government. Size, height, etc. of the small house requires strict compliance. For example, for the second and third floor, you can have a balcony 2.5 meters protruding into the airspace. Now you must comply with this requirement. You cannot have 2.6 meters or 1.5 meters, for example. Because only when you copy the basic design provided by the government, you can enjoy the protection of the free certificate for exemption. If you deviate from that approved design, then yes, you can do so, but in the buildings ordinance will apply, and you have to get the approval of the director of lands for him to approve your building plan. That would be costly and time consuming. So everyone would just follow the government's design for building the small house. And therefore, if you deviate from the plan and without getting the permission of the building authority, then your house certainly would have no good title. Okay? Now, you may be very frustrating, right? All this difficult law. Now, the good news about is that because I claim to be an expert in new territories land, so each time I teach land law, I will spend half of the lesson to talk about new territories land. But they are not exactly in our syllabus. Yeah, they mentioned that it's mentioned small house. They mentioned those Zhou and Tong. But for I have taught this course, I think over 15 years or so, and have never seen an exam question asked on that topic. So this is just for your information, okay? Don't make complaint to space. So far, my students have not made any complaint to space about talk about the new territories land, because I think it is a very interesting situation in Hong Kong. Even before 1997, we have one country, two system, or one city, two system. The land system in new territories is completely different from the land system in Hong Kong Island or the Kowloon south of Boundary Street. This is a very, very peculiar situation in the whole world. And remember, I said in Monday, many foreign lawyers who want to practice in Hong Kong actually has make petition to the Law Society. Well, we definitely would not touch the new territories land. Please allow us not to sit that exam, because they find all this concept very complicated. They're not yet the time. In fact, they are very difficult. But for people like me who have practiced this law for so many years, basically you can ask me any question, I can give you answer right immediately. Of course, if it is chargeable, I will not do that, because I would say, I need time to consider. Pay me 50,000 for written advice, or 100,000 for my written advice, etc. But that is money generating, not just for the developer, but for lawyers, practicing in this area. Okay, now anything after this slide are examinable. Anything before this slide in the second lecture is just for your information. Now, if you look at the workbook, I believe they also mention small house and the Zhou and Tong, but you just know about them, it's all right, because, as I said, they have never been asked in the exam, because the examiner knows that it is really complicated. If you are required to study this law, then it may be too much for you. This module is already too complicated. There's so many difficult concepts. Therefore, we deliberately, leave the new territory land aside for exam purpose. Okay, we come back to our syllabus. Legal estate, we are talking about estate and interest. Legal estate is defined in CPO. Terms of year absolute. What does that mean? We have already talked about this concept. Terms of year absolute. A definite beginning and a definite end, right? So, if you want to have a legal estate, it only refers to a list terms of year absolute. This is copying from the section itself. The legal interest in any easement, remember? The interest in land belonging to your neighbor, okay? Right or privilege in an overland for an interest equivalent to a terms of year absolute. Okay, so this is comparable right, comparable interest and legal to a lease and legal charge. Now, what does it mean in this section? It means if you want to have a legal estate, you can only have legal estate for a list, for an easement, and for a legal charge. Any other interest not mentioned in this section could only exist in equity as equitable interest. So this is the first concept that you have to remember. There's no logic, but that is the statutory definition. In this same section, equitable interest is defined to mean any estate, interest, or charge in or over land which is not a legal estate or freehold. So any proprietary right in land which is not a legal estate must exist as an equitable right or equitable interest. To make things easy, look at this diagram. Legal estate would include a lease and sometimes called tenancy. Usually, if it is a long duration, we call it a lease. If it is short duration, we call it a tenancy. Meaning is the same. Or interest equivalent to lease or tenancy, easement, and charge. For equitable interest, it could be lease, tenancy, or interest equivalent. The difference between equitable interest and legal estate is a matter of format. We'll come back to this. Easement, charge, mortgage. Now, mortgage is no longer recognized in law, but you can still have mortgage as equitable interest. Land covenants. Now, these are some agreement between landowners in relation to the use of certain land. This will give interest to you in land either belonging to you as well as belonging to others. But this is not recognized in Section 2 as a legal estate. So you can only have equitable interest in relation to land covenants. Now, we will have a chapter to discuss easement and land covenants, so don't worry at this stage, but just have this label first. Okay? Now, we say the difference between legal estate and equitable interest in some cases, just like lease and tenancy, could be just a different or matter of format. What do I mean? We'll come back to this slide later. Under Section 41 CPO, a deed is generally necessary to create, extinguish, or dispose of a legal estate in land. Now, reading Section 2 and Section 41 together, it will mean if you want to create a legal estate in lease or tenancy or easement or charge, you have to create it by deed. What is a deed? A deed is a written document which is the three magic words: sign, seal, and deliver. That is to say, not only signing on that document, you have to put your seal. If you are a company, you would have to put your steel seal. Sign, seal, and deliver. Sign, if you have your seal, in the old days, the Englishmen, all Englishmen have a seal. Usually, they put the seal in their ring, so they put the seal, put the ring to impress some on that paper. And deliver. Deliver means you give this piece of document to the recipient. That is deliver. So if you assign a property to the purchaser, you create an assignment. And then at the end of the assignment, you sign on the assignment. You are the assignor, you are the landowner. You assign this property to the purchaser. You sign, you put your seal there, and deliver this assignment to the assignee, to the purchaser. And that would complete this legal creation of legal estate. Now, you can hold the legal or equitable title to a legal estate and equitable interest if that legal right is created as a legal estate. Then you can have the legal title to that legal estate. If the legal right is created as an equitable interest, then you would have an equitable title to that equitable interest. So a person can hold a legal estate or an equitable interest to an easement, because easement could exist as a legal estate as well as equitable interest. But you can only have a legal title to a legal estate and an equitable title to an equitable interest. Now this is also another difficult concept. I remember when I studied land law, all these are so confusing. But nowadays, of course, everything is so clear and straightforward from my eyes, but not from your eyes. Okay, maybe this is a good time for us to call it a date. So I see you next Monday. Take some time to read a little bit your textbook and the slide. That would help you to understand my lecture better.